Regardless of what helping profession you decide on, you will face ethical dilemmas. Part of becoming a competent practitioner involves being able to apply the ethics code of your professional organization to practical situations in your work. In the Files menu on the left-hand side, under Handouts, there are several current code of ethics from the different organizations that you may be involved with in your future work. Take a look and become familiar with the types of situations that codes of ethics cover. It would also be interesting to compare and contrast the different codes of ethics for different situations. Are the organizations always the same in their guidelines? Probably not. Here is where your professional judgment gets to be developed. Of course, ethical practice involves far more than merely knowing and following a professional code of ethics. In dealing with ethical dilemmas, you will rarely find clear-cut answers. Most of the problems are complex and defy simple solutions. Making ethical decisions involves acquiring a tolerance for dealing with gray areas and for coping with ambiguity. Some new counselors are searching for the right answers in ethical decisions and say to me, "I just need the answer," or "just tell me what to do." My first answer is always, what does the law and regulations say to do? What do our policies and procedures say to do? What do our code of ethics say to do? What do you think you should do? It is more important to help the new counselors learn how to develop the resources to deal intelligently with ethical dilemmas, because there will be many a time that an ethical decision comes up and there is no one in the session with you to help you make the decision at the moment. Professional judgment is to be developed and learned, discussed, and then explored by talking with others and thinking about the situation yourself to finally hone in on a course of action within an ethical dilemma. Law defines the minimum standards society will tolerate. These standards are enforced by governmental agencies. When confronted with a legal issue, it is always best to consult an attorney to determine which course of action to take. Some areas governed by the laws include confidentiality, parental consent, informed consent, protection of client welfare, and civil rights of institutionalized patients. Ethics, however, represents the aspirational goals, or the maximum or the ideal standards set out by the profession. Ethical standards are enforced largely by the professional associations. How many of you think that there is always the same rules in both the legal and ethical arenas? That there was never a conflict? Not so. When there is a conflict, the best solution is to obey the law in a manner that minimizes harm to their ethical values, or to adhere to their ethical values in a manner that minimizes the violation of the law. Many times these conflicts between law and ethics can be prevented and take proactive measures. For example, clearly spelling out things in your initial sessions with clients, having clients sign contracts so that there is no misunderstanding of the roles and responsibilities. If you conscientiously practice in accordance with your accepted ethics codes, then you have some measure of protection in case of litigation or lawsuits. However, you will need to grapple with the gray areas, raise questions, discuss your ethical concerns with your colleagues and your supervisor, and monitor your own behaviors. Again, several of the Code of Ethics are listed in the Files menu on the left-hand side in the Handouts folder. There are even more examples of Code of Ethics in your textbook with the website addresses. Feel free to read those over at this time. This is a really good model for ethical decision making presented in your textbook by Corey and Corey. The first step is to clarify the situation that you are facing. Is it an ethical, legal, professional, or clinical problem? Is there a legal element? Then seek legal consultation from an attorney. If there is an ethical element, remember that ethical situations are quite complex, and you will need to consult several different perspectives. The second step is to review the potential issues involved. Are there cultural aspects here? How can I best promote client independence and self-determination? What actions have the least chance of bringing harm to the client? Keeping the client in mind is primary to making an ethical decision. The third step is to apply the relevant code of ethics. Then keep up to date on relevant state and federal laws and regulations, and consider the rules, policies, and procedures of the organization where you work. It is generally helpful to consult with one or more colleagues or with a supervisor or other expert to obtain different perspectives on the problem. Consultation and supervision may help you think about information or circumstances that you may have overlooked. It is important to document the consultations that you have received directly into the client's record, including the suggestions provided to you and the reason that you chose to follow or don't follow the directions given to you. List different potential courses of action and identify a possibility that looks most useful to you. Explore the consequences of this potential action. If needed, continue brainstorming and consulting with others to get to a solution or a course of action that you feel comfortable with consequences that minimize your risks to client harm. Lastly, have the courage to implement the course of action that you have decided upon, and again, document the results and reactions in the client's record in specific terms, using quotes, signed documents, or other specifics such as next steps, times, and dates when actions were taken, and so forth. Informed consent involves the right of clients to be informed about what their relationship with you will entail and to make autonomous decisions pertaining to it. There is usually an informed consent document to be discussed and sometimes signed between the practitioner and the client. The informed consent document, sometimes called a contract, describes the boundaries and clarifies the nature of the basic counseling relationship between the counselor and the client. Informed consent for treatment is a powerful clinical, legal, and ethical tool. A document is helpful because the clients may not remember everything that you told them at the first session. They can take the document home and review it and ask further questions in the next session. It is best to remember that informed consent is not a one-time process, but rather ongoing. Here are some of the questions that the informed consent process should address. What are the goals of the helping relationship? What services are you able and willing to provide? What do you expect of your client? What do you want to tell the client about yourself or your organization? What are your qualifications as the provider of the services? What are the financial considerations? Do you offer a sliding scale for clients who cannot afford the fee? What is the estimated duration of the professional relationship? Are there any alternatives to the treatment? What are the risks and benefits of the treatment? The helping relationship is built on a foundation of trust. Trust is largely measured by the degree to which clients feel assured that what they say will be listened to and kept confidential. Helpers must not disclose this information except when required by law or authorized by the client to do so, usually in writing. However, it is important to realize that confidentiality is not an absolute, especially in family and couples counseling, in the treatment of minor children, and in group counseling or school site counseling situations. We encourage and discuss confidentiality specifically in these situations and continuously remind clients of their obligations and the benefits of confidentiality. However, because information is being shared in the context of other relationships in these situations, the practitioner cannot always guarantee confidentiality by others. Confidentiality must be breached under specific circumstances, and these are really known as the Big Four: harm to self, harm to others, child abuse, and elder abuse or dependent adult abuse. Know these, as these are the exceptions to confidentiality that your client must be informed about in the first session, almost before they even open their mouths. It is a great idea to include in your informed consent statement provided to the clients about the issues of electronic means of communication, such as email, texting, and patient portal access, such as the risk to confidentiality and the expectation of turnaround times. Each healthcare organization has a notice of privacy practices it presents to the client at the initial contact. Your discussion forum for Chapter 8 is around the new technologies and how you may choose to use or not use them in the course of your helping relationship. What is your view on Facebook, texting, and emailing with clients? How will you set the boundaries and be able to ensure confidentiality? From an ethical, legal, and clinical perspective, you are responsible to keep adequate records on your clients. It is considered below the standard of care to fail to keep current records for all of your professional contacts. For example, the standard of timeliness to document client contacts on a daily roster, which is to be turned in at the end of the business day. However, you generally have up to the end of the same week, by Friday, to document all of your progress notes on a client that you saw during the week. However, if you are involved in an ethical decision or having to take action, say on a child abuse report or a suicidal client, then these ethical issues need to be documented into the client record by the end of the same business day. Your client's record can never be altered once you have made a client entry. This is more difficult now that everything is in an electronic health record. You can add to the record, but you cannot delete it. Timelines and signatures are also electronically date and time stamped in the electronic health records, so paperwork becomes very prescribed and monitored. Progress notes are required for each client contact. Progress note includes what the client and the counselor did and said during the encounter. They also include treatment plans, assignments, dates of next appointments, and documentation of referrals. Process notes are more like your own personal notes of the counseling process. This involves your observation of the clinical process, transference and countertransference issues. These types of notes should not be included in the electronic health record because they are not meant to be shared with anyone else. Remember that clients have a legal right to view their record or a summary of their record, and so your documentation at all times should be professional, thorough, and factual. If you did not write it down, then it didn't happen. A well-organized and well-documented client counseling record is the most effective tool a counselor has to establish the quality care that they provided. The managed care model is characterized by time-limited interventions, cost-effective methods, careful monitoring of services, and prevention more than curative strategies. The goal of the managed care model is to provide services that are as brief as possible to ameliorate the presenting problem. Malpractice is generally defined as the failure to render proper service through ignorance or negligence resulting in injury or loss to the client. Professionals are judged according to the standards that are commonly accepted by the profession. That is, whether a reasonably prudent counselor in a similar situation would have acted in the same manner. Common sources of complaints lodged against professionals are listed here. Professional journals reveal that an increase in citation for the abuse of alcohol and drugs is noted because of the possibility of impairment of professional judgment. It should be noted that these abuse of alcohol and drugs is not during the session. This can be off hours on the weekend, being arrested for a DUI, which proves the impairment of judgment in the counselor's personal life, which translates potentially to an impairment of professional judgment. So this is important to notice in the citations for malpractice. It cannot be emphasized enough that adequate documentation is essential in defending yourself in any malpractice action. Ask yourself these questions throughout your professional career. What am I doing? Why am I doing it? Would I be doing the same thing if my colleagues or the public were observing me? Recognize that unethical acts are often subtle and unintended. Maintain a stance of honest self-exploration to ensure that you always have ethical behaviors. Go on to the discussion forum for Chapter 8 and then go on to the quiz for Chapter 8.